legal framework en de practices in Duitsland zal uiteenzetten van het standpunt en gebracht door het Nationaal Contactpunt van het Europees Migratienetwerk in Duitsland. Maar Ina, alsjeblieft, je hebt het woord.
Thank you, Koen. I will speak in English. And maybe if there are still people standing, there are still seats there. We just watched a short video on the topic of beneficiaries of international protection traveling back to their country of origin. The video is intended to be a teaser, so it's for wanting to know more, and we hope you want to know more because we're going to talk about it in this last session. I will do my talk about the Belgian report, but I will refer a number of times to the European situation in other countries as well. Just as a background, every year the European Migration Network does 4 thematic studies, and every member state can do proposals for this study, as well as the European Commission. This study was initiated by Belgium in 2018, and then a questionnaire was made, and on the basis of this questionnaire, 26 national reports were made, including from Norway and Switzerland. And just a few weeks ago, at the end of October, the synthesis report was published. So you see on the slide both the Belgian and the synthesis report. I would like to start my talk with giving you some newspaper headlines from recent years. It's headlines from papers in Belgium, but also from Switzerland and the Netherlands. In these articles, you see how traveling back to the country of origin for beneficiaries of international protection is presented as holidays at home, saying it's abuse of international protection status. To give you also another part of the coin is some pictures from the video we just saw, and it's bringing in the perspective of the beneficiaries of family reunification themselves. From what we understand at the asylum office, in many interviews, they refer themselves to explain and justify travels to the country of origin to family reasons. So, for example, visiting an ill family member. So just to say that it's a complex picture and that every case will need to be looked in by the asylum authorities to judge so to have really a case-by-case approach. This brings me to the following point. A case-by-case approach, so saying there is no automatic loss of international protection status for someone traveling back. And this is also the case in all other member states. With one exception of Hungary, there is no automatic loss of international protection status. It can, however, lead to a reassessment of international protection needs. And why? Because it can be an indication that international protection is not or no longer justified. It's interesting, in Belgium, there is no formal prohibition to travel to the country of origin. This is something that derives from the law, from legislation in general, and also from case law and national practice. Beneficiaries are informed of this prohibition in a brochure they get at the moment they are granted status. But what is also interesting, it is in Belgium not indicated on their travel document that they cannot travel back to the country of origin. We see in a number of countries that this is indicated, for example, in Germany and France, but also Austria. So, like I said, there is no automatic loss of status, but there can be a reassessment of international protection status. When it concerns travels to the country of origin, it is established practice in Belgium that voluntary travels can result in a decision to end status. And this is both the case for refugees and for beneficiaries of subsidiary protection. The study also goes, but we will only touch upon it, on contacting the authorities of the country of origin, for example, to get a passport, then the picture is a bit different. When it concerns a refugee, it can indeed lead to a reassessment of the status. In general, for beneficiaries of subsidiary protection, this will not be the case. But again, very important, it is a case-by-case approach, and it depends on very different factors. To give one, for example, the relation with the actor for persecution, if this is a non-state actor or not, but this is just only one example that is looked into. This is a picture of the entire process, its different actors and different phases of the process to detect, to review the international protection status, but also to review the residents' rights. If we start with the first one on detection, it's the Immigration Office, and it's who collects all the information from different stakeholders on information about potential travels to a country of origin. And the Immigration Office can also initiate a request to the Asylum Authority to reconsider status. Then it's the Asylum Authority, in Belgium an independent administration, the Commissioner General for Refugees and Stateless People, who is competent to actually decide on the protection status. And it's open to an appeal for the Council for Alien Law Litigation. But it's not because an international protection status is ended that residence rights are ended. This is, again, a different decision. It's, again, the Immigration Office who is competent to review this and to look if it's legally possible and proportionate to do so. And then it's open again to an appeal for the Council of Alien Law Litigation. What we see in recent years is that the issue became much more of a focus. So the Commissioner General, the Asylum Office, always had the possibility to reconsider protection statuses following travels to the country of origin, and it did so. But it was more sporadically, I would say. We see from 2014 on, it became in the federal government agreement in Belgium. And then different measures were taken, giving much more focus on this and really going into information gathering and exchange on potential travels to the country of origin. Before looking into some of these measures, I would like to point out that it's not in all member states a political topic. It is, for example, in Germany, the Netherlands, Switzerland, and some others on the slides, but in many other countries, there is not that much attention given to it. If we go into some of the measures that were taken in recent years, like I said, it's most on information gathering and exchange. And you see the first one, there was in 2015 really a collaboration set up between the Immigration Office and the border police, the police in charge of border control, to exchange information they have and to give it through. It's, for example, observations they had at the border of someone traveling with a refugee, for example, traveling with a passport from the country of origin, but also information of stamps on the passport or traveling, indications of travels with two different passports. Another measure taken is that in 2017, October 2017, inside the Immigration Office, there was set up a specific service, a small unit called the International Protection Follow-up Unit, with the task to collect information and to initiate requests towards the Asylum Authority. A third one we can mention is that also instructions were given to the municipalities and the Belgian embassies to collect information, for example, in the framework of a family reunification, if they find information on travels to a country of origin. And then one last one beyond the national level is that collaboration was set up with different member states to exchange information. And why is this? Because people, of course, also use airports of neighboring countries to travel and to exchange also with the border police of these countries. So in 2016, 2017 and 2018 respectively, a collaboration was set up with the Netherlands, Germany and Italy. A word on terminology. There are different grounds for ending international protection, and in general we will talk about ending international protection status as an umbrella concept. But we see that for specific grounds there are diverging definitions between the Refugee Convention and the Asylum Acquis. In general, it's quite clear on what is cessation, that cessation means the status ceases to apply and international protection is no longer needed or justified. But on other grounds, there are more diverging definitions, and we talk for the Belgian one on withdrawal, retrait, intrekking, and this meaning is very different from the cessation concept, saying that the status should have never been granted. So in a cessation, he was granted, but he no longer is needed or justified. When we're talking about withdrawal, it should have never been granted. This slide is on the different legal grounds in the context of travels to the country of origin to end international protection status, and I'll go quickly through them, but I do want to point out the one that is the most common ground in different European countries to end in the context of travels to the country of origin, and that is the cessation, which in Belgian law just refers to the Geneva Convention and situations in Article 1C of the Geneva Convention. And the most commonly here is the person voluntarily re-availing to the protection of the country of origin, of nationality. Maybe one word about it. Again, it's a case-by-case approach, and there are no clear guidelines in Belgium used, but different ones from the UNHCR handbook and so far. But they are really, the protection officers are really going to look into the case. They're going to look at the frequency of the travels, the length of stay, the specific place of stay in the country of origin, the circumstances of the stay. For example, if the person stayed there living in hiding or not. Like I said, the relationship with the actor of persecutions. So it's the complete pictures that is being looked at. Subsidiary protection goes, and I will not go into it, it's on the change of circumstances in the country of origin, and this should be significant, sufficiently significant and of a non-temporary nature. And here, in fact, it's often the travel to the country of origin which actually confirms the change in circumstances. And then withdrawal, which is mostly on fraud, and the personal conduct indicating that there was no protection need at the beginning, ab initio. On ending residence rights, it is important if we're talking about a cessation decision or a withdrawal decision. And this is important in the face of ending residence rights. Again, like I said, there is no automatic end of residence rights. It's now the Immigration Office that needs to look into it and see, taking into account individual circumstances, but also what is legally possible. To refer to other countries, just to say that in a number of countries, more than a third of the countries in this research, there is indeed an automatic end of residence. If I'm referring to the Netherlands, for example, this is one decision. They will not end international protection status if they cannot end residence rights. So it's a different system. To say for Belgium, there is a time limit in case of a cessation decision, and I'm only talking here in the context of travels to the country of origin. So they can only end it during a residence permit of limited duration. If the Commissioner General has taken a withdrawal decision, they can end residence rights at any time. And to end my presentation, I would like to give some statistics, and this specifically on the face of ending international protection, so not on the residents' rights. But in 2016, 17 and 18 altogether, the Immigration Office requested the Asylum Authority to reconsider international protection status in more than 400 cases, all based on travels to the country of origin. This is a number that has been increasing over these years between 2016 and 2018. If we look at the decisions, we see that about 120 cases are still pending, but of those where there is a first instant decision, in about 60% the decision was taken to end international protection status, meaning that in 40% international protection status was not ended. I thank you.